Yeah, no, I just want to mock the court because of what he said. You buy something in courts and you don't pay, you apply for gyro, everything goes from your salary. The law will come after you. But this is your family, this is what you worked for. And you signed a paper with this woman, you know, and the law cannot enforce. Yeah, and the law cannot enforce. I'm really seriously sorry for the law.
Yes.
Okay? Policies and laws are made to protect people,
Yes.
their lives,
Agreed.
the human. Okay? Let's not talk about woman or man. The human nature. When you enacted this law in 1961, in the 50s, I was born 6 years later. Okay? That time, there was a lot of family violence. Yes, man beat woman, woman beat man, that's normal from where I came from. But there was harmony, you know, they trash it out and there was harmony. But now we are educated, we are no more cavemen. The thing is, because of education, we are abusing the law and destroying the family. I've heard a lot of words from all of you all in the panel, you know, family violence, you know, child abuse by the mother against the father. Maybe you must enact a law, you know, so that the mother cannot groom the child against the father in the case of divorce, or the other way, right? What I'm coming at is, how are we going to change this law, which was enacted in 1959, changed in 61 and now in 2011, to suit the modern day family, where the woman is earning enough and the man is also earning enough, and the children are also studying. Okay, everybody is looking at each other for the equal partnership in the family. How are we going to teach the children to lead a family better than how we led? Okay, to me, my family rule is, you will never use the D word, the divorce word. When you start using the D word, that's when all hell breaks loose. You know, I always tell my wife, you do not urge me to get angry. When I get angry, I may do things that you may not like. I will do the same. That's partnership rules. I think what the law should seriously consider is the 3-year period, you know. Force these two people, the husband and the wife, to go for serious therapy and counseling before the law actually decides, here you go.
Is that provided for right now?
Yes, under the new act,
They have
pre-
to go through
it is mandatory that before you file the divorce, you have to go through pre-divorce counseling. It's in the legislation. The structures are all being set up. Obviously, MSF will be, one of the agencies, right, who will be overseeing that. So it's not been implemented yet, because the new Family Justice Act and the Family Justice Rules will be implemented in phases. We just can't put everything all, 1st January and everything starts running. So some parts have been implemented already. The rest are coming up in phases. Right? So in that sense, the point you made, yes, there will be pre-divorce counseling. And before you even file the divorce, one of the documents you will have to file to get a divorce is like a little certificate, right, that you have attended the pre-divorce counseling. So that will become one of the requirements.
Christopher, yeah, you wanted to add something? Yeah.
I'd just like to say that I agree and I disagree with Silvam, because I think what's actually getting to the heart of the issue is that the family is a very uneasy locus where the state and the law have to intervene. And it seems to be the case we've heard for, in terms of the definitions of family, how and what the law should do. So I guess the question I have is that what we have is, we are talking about an evolving law. We also have a family sphere that is trying to increasingly define itself autonomously of the state and of the law. And what I'm wondering is that from the legal profession and from the counseling profession, where is the limit? Because I agree that the law has to keep up with changing times, but I disagree that the law has to intervene more into the locus of the family. So I'm not sure how you see that tension from your perspective. Should there be a limit after which we say the law can no longer go here,
Or the law should.
or the law shouldn't go here? I guess that's how I.
Great question. Anama.
I think even before the, pre-counselling, before the divorce, they should have done the marriage counselling earlier,
Yes.
which they have put into practice now, which is quite good. But I think even before the laws were passed to ensure that there's some kind of counselling before the divorce proceeds, the family court has already started much earlier on to have counselling as soon as any divorce is filed. And in the early days it was if they have children below the age of 8. Now it's up to 21. So they have progressed from below 8, then up to 14, then now it's 21. So there has been progress over the few years. And then until the Family Justice Act, which was passed, it's called the Family Justice Act. Yeah. And that comes into operation from 1st of January 2015, quite new, and therefore that's where Mr. Yap has said that, implementing all these requirements as we go along. So now we are going to have pre-divorce counselling. That means before you file your divorce papers, you have to go for counselling.
It's already in place, right?
Yes.
Pre-divorce
Yes.
counselling. But maybe to respond to your questions and your comment, we should look at alternative dispute resolutions. Right. Now, law is just one way of settling issues. But as a society, and this would be a useful concluding point for us, as a society, should we not start seriously looking at alternatives to legal recourse?
Absolutely.
Should legal recourse not be the last recourse? But a lot of times, because we're becoming very litigious as a society, litigation seems to be the first course of action. But as a society, should we not start moving in that direction? Jagjit, what do you think?
Yeah, in fact, we are so grateful when a couple actually walk in and say, you know what, I need help. I'm seeing some cracks in my marriage. And that's what we're looking for. But the issue and the problem here is the perception about counselling. Somehow it's the Asian, and so much so even some of the minority communities, they see counselling as only when I have problem I go to counselling. So the view about counselling. But seriously, when a woman call in and say, something is not right, and we often tell her, good, you can come in, I can work with all your emotions and everything, I can help you. But your partner need to come in, because whatever work I do with you, when you go back, you're going back to the same environment. So if you were to say, we are very happy before you get to the law, we acknowledge them, we tell them thank you, thank you for coming, and which means you see some hope. And it also validates the point that they want to make the marriage work, they want to put in the effort. So this is what we look forward to. What saddens us is when we have to do mandatory counselling. As compared to counselling, as a counsellor being in this profession, I can tell you, when I have to do counselling, I think it's more fulfilling than doing mandated, because seriously, they're not happy. These guys walk in, they probably have heard this women, and they're going to come in and see another woman like me. So it takes time
just
for
going
us.
through the motions.
Yes, they just do. And sometimes it's so challenging because they say, okay, are you done? The court. I say, no, I'll report to the court, and they don't turn up. So sometimes all this fear and dread, but at the end of the day, but like
Sure.
what Anima said, the PPO is good in the sense that at least they are getting help. So what we do is we say, okay, let's work on this issue. And then we go to the couple work. Because we need to address this first. Once we are able to fix this, then we'll say, okay, both of you are ready. Now we'll do the couple work. So
Yeah.
them coming to us before the law is much
Yeah.
more. Yeah.
Jangga?
Well, alternative dispute resolution certainly is a big movement now. Certainly it has been when the Women's Charter was amended in 2011. It was already, it gave the courts the power to order parties to go for mediation. In the past, mediation was voluntary. Right? So, it's a question of
Yeah.
whether you volunteer,
Yeah.
and you can't, the courts didn't have the power to enforce it. But with the 2011 amendments, they could order parties to go for mediation to resolve their disputes or counselling. Certainly in the PPO aspects, as part of the orders the court can make, it can order parties to go for counselling, and PAVE is one of the organizations,
Yes.
right,
Yeah.
which are involved in that kind of counselling. Certainly in the new Family Justice Act, the ethos and the whole approach really is, as you said, the court is the last resort, right? So a lot of it is really to see what other areas we can resolve the dispute without going to court. So mediation is one. Collaborative family law is another area of alternate dispute resolution, right? Mediation can be in different forms, and there are so many avenues of mediation, whether it's private, whether it's through the Singapore Mediation Centre, whether it's through the courts, and certainly in the amendments to the 2011, also the focus of the Child Focus Resolution Centre was one of the things, and you know, in Central Mall now is actually it's part of the Family Justice Courts, but it's a dedicated office area where when you have children, you have to go through that. Okay, it's mandated. Okay, for parents to go, and they'll sit in with a family counsellor who will speak to both the parents. Right? So that is already in process, and that's, I think, proven to be a success. Okay.